I never imagined that painting my fence would land me in a legal battle that would expose the entire HOA board as frauds. But that's exactly what happened when Patricia Montrose decided she owned my property line. It started on a humid Saturday morning in June 2024, when I was standing in my driveway in Clearwater, Florida, staring at the weathered wooden fence that separated my backyard from the community's common area. I'm Brandon Reeves, and I had just bought this house 6 months ago, a modest 3-bedroom ranch-style home in the Sunridge Hills development. The fence desperately needed attention, with peeling paint and a few boards that were starting to rot near the bottom. I had done my research, checked the HOA's covenants, conditions, and restrictions, and found absolutely nothing that would prevent me from repainting my own fence in a color that matched my house's trim. I had chosen a pleasant shade called desert sand, a neutral beige that would complement the light gray siding of my house. The paint cans were sitting in my garage, the brushes were ready, and I had taken the day off work specifically for this project. I work as a software engineer for a tech company downtown, and weekends like this were precious for home maintenance. As I started moving the paint supplies to the backyard, I heard the sharp clicking of heels on the sidewalk. I turned to see Patricia Montrose, the HOA president, marching toward my driveway with her phone held up like she was recording me. Patricia was in her early 50s, with bleached blonde hair styled in that particular way that screamed, "I want to speak to the manager." And she wore a pressed white blouse with capri pants despite the 90-degree heat. "Excuse me," she called out in a shrill voice that made my teeth clench. "What exactly do you think you're doing?" I set down the paint can I was holding and turned to face her with what I hoped was a polite smile. "Good morning, Patricia. I'm just about to repaint my fence. It's been looking pretty rough." Her eyes narrowed, and she lowered her phone slightly, though I noticed she kept it pointed in my direction. "That fence is HOA property, and you cannot make any modifications without explicit written approval from the Architectural Review Committee." I felt my stomach tighten, but I kept my voice calm. "Actually, Patricia, I checked the property survey when I bought the house. The fence is 6 inches inside my property line. It's completely my responsibility and my property." "That's absolutely incorrect," she snapped, her face flushing red. "That fence has always been maintained by the HOA as part of the common area landscaping. I've been president of this HOA for 8 years, and I know exactly what property we own." I reached into my back pocket and pulled out my phone. "I have the survey right here if you'd like to see it." The county records are very clear about the property boundaries. Patricia didn't even glance at my phone. Instead, she raised her chin and crossed her arms. "I don't need to see anything. I'm telling you right now, if you paint that fence, the HOA will take legal action against you for destruction of community property. We will sue you for damages, legal fees, and any costs associated with restoring the fence to its original condition." My hands clenched at my sides. I had dealt with difficult people in my career, but there was something about Patricia's absolute certainty in the face of documented evidence that made my blood boil. "Patricia, I really think you should look at the survey before making threats. I have every legal right to maintain my own fence." "We'll see what our lawyer has to say about that," she said, turning on her heel. "Consider this your official warning, Mr. Reeves. Touch that fence and you'll be hearing from our attorney." She stalked away, her heels clicking aggressively against the pavement. I stood there for a long moment, paint supplies scattered around me, trying to process what had just happened. Part of me wanted to go ahead and paint the fence anyway, but I knew that Patricia was vindictive enough to follow through on her threat, even if she was completely wrong. Instead of painting, I spent the rest of that Saturday afternoon photographing the fence from every angle, documenting its condition and its clear position on my property. I pulled up the official survey again on my computer and made several copies. Then I started digging through the HOA's CC and Articus line by line, looking for any clause that could possibly support Patricia's claim. There wasn't one. The CC and Articus were very specific about what constituted common area property, and private fences on individual lots weren't mentioned anywhere. The Architectural Review Committee did have approval authority over certain external modifications, but routine maintenance like repainting in a neutral color wasn't on the list of things requiring approval. By Sunday evening, I had compiled a comprehensive file of documentation. I wasn't going to let Patricia bully me into abandoning my property rights, but I also wasn't stupid enough to walk into a legal fight unprepared. On Monday morning, I was in my home office catching up on some code reviews when my email pinged. The subject line read, "Urgent legal notice violation of HOA property rights." My heart sank as I opened it. The email was from Patricia, sent to me and CC'd to the entire HOA board, which included 4 other people I had barely met since moving in. The message was 3 paragraphs of legal-sounding language that essentially repeated her threat from Saturday. She claimed that I had been observed preparing to vandalize HOA common property, and that the board had unanimously voted to pursue legal action if I proceeded with my unauthorized and illegal fence modification project. What struck me most was the tone. Patricia wrote as if she were already consulting with an attorney, throwing around phrases like willful destruction of property, breach of fiduciary duty to the community, and injunctive relief. The email concluded with a demand that I sign a written acknowledgement that the fence was HOA property, and that I would cease and desist all plans to alter, modify, or otherwise interfere with said property. I read the email 3 times, feeling my anger build with each pass. The claims were not just wrong. They were so wildly off base that I couldn't believe Patricia actually thought she could get away with this. More concerning was that she had apparently convinced the other board members to go along with her. I needed a lawyer, and I needed one fast. I spent my lunch break researching real estate attorneys in the Clearwater area. After reading through a dozen websites and reviews, I found someone who seemed perfect. Michael Chen, a lawyer who specialized in HOA disputes and property rights. His website featured several case studies where he had successfully defended homeowners against overreaching HOA boards. One case in particular caught my eye, where he had gotten an HOA sanctioned for bringing frivolous legal action against a homeowner who had installed a solar panel. I called his office immediately and was pleasantly surprised when his receptionist told me he had a cancellation that afternoon and could see me at 3 o'clock. Michael Chen's office was in a modern building near downtown Clearwater, with floor-to-ceiling windows that overlooked the bay. Michael himself was younger than I expected, probably in his late 30s, with dark hair and sharp, intelligent eyes. He greeted me with a firm handshake and gestured for me to sit in one of the comfortable chairs across from his desk. "So," he said, leaning back in his chair, "tell me about your HOA problem." I pulled out my laptop and walked him through everything: the fence, the property survey, Patricia's confrontation, and the threatening email. I showed him the CC and Articus, my documentation, and the email chain. Michael listened intently, occasionally making notes on a legal pad. When I finished, he was quiet for a moment, studying the survey on my screen. Then he looked up at me with an expression that was somewhere between amusement and disbelief. "Mr. Reeves, this is one of the most clear-cut cases I've seen in years," he said. "Your HOA president is not just wrong, she's spectacularly wrong. This fence is unequivocally your property. There's no gray area here. Relief washed over me, but I still felt tense. So what do I do? Just ignore her threats and paint the fence. Michael shook his head slowly. Normally, I'd say yes, but this email she sent changes things. She's already threatening legal action, and based on the tone, I think she's going to follow through. Here's what I recommend. Let me send her a letter laying out the facts and the law. I'll make it very clear that her position has no legal standing and that if she pursues this, she'll be wasting the HOA's money on a frivolous lawsuit. And if that doesn't work, then we let her sue, and we counterclaim for attorney's fees and ask the court to sanction her for bringing an action with no basis in law or fact. Florida has very strong statutes against frivolous litigation, and HOA board members can be held personally liable when they act outside the scope of their authority. The idea of being sued, even for something I knew I would win, made my stomach churn. But I trusted Michael's assessment, and I wasn't going to back down from Patricia's bullying. Okay, I said. Let's send the letter. Michael drafted the letter that afternoon while I waited. It was a masterpiece of legal writing, polite but absolutely devastating in its precision. He laid out the property survey results, cited the specific Florida statutes governing property boundaries and HOA authority, and explained in detail why Patricia's claims had no merit. The final paragraph was particularly pointed. It warned that any legal action based on the HOA's current position would be considered frivolous, and that we would seek sanctions, attorney's fees, and damages for harassment. He sent the letter via email and certified mail that same day. I went home feeling cautiously optimistic that Patricia would see reason once she realized I had legal representation. I should have known better. 2 days later, on Wednesday evening, I found a formal legal document taped to my front door. It was a notice of intent to file a lawsuit, prepared by a law firm I had never heard of, Davidson and Partners, based in Tampa. The notice repeated all of Patricia's baseless claims and added a few new ones, including that my hostile and threatening behavior toward Patricia had created a hostile environment in the community. I immediately scanned the document and emailed it to Michael. He called me back within 20 minutes. "Brandon, this is exactly what I was afraid of," he said, and I could hear the frustration in his voice. "Patricia has hired an attorney, and either she lied to him about the facts, or he didn't do any due diligence. Either way, this firm is about to make a very expensive mistake. What happens now? They have to actually file the lawsuit for us to respond. Once they do, I'll file our answer and our counterclaim. But Brandon, I want you to understand something. This is going to get ugly before it gets better. Patricia is doubling down on a position she knows is wrong, and that means she's either delusional or she has some other agenda. Either way, we need to be prepared for a fight." The lawsuit was filed the following Monday. I was served with papers by a process server who showed up at my house at 7 in the morning, interrupting my breakfast. The complaint was 23 pages long, filled with inflammatory language about my flagrant disregard for community standards and intentional destruction of HOA property. They were seeking an injunction preventing me from touching the fence, damages of $25,000 for diminution of property values, and attorney's fees. Reading through the complaint made me physically ill. The allegations were not just false, they were absurd. Patricia's attorney had apparently taken her word for everything without bothering to verify any of the facts. There was no mention of the property survey, no acknowledgement that I had documentation proving my ownership of the fence, nothing that suggested any actual legal research had been done. Michael filed our response 2 weeks later. Our answer denied every allegation in the complaint and included a detailed factual background with exhibits. The property survey, the CC and Rs, photographs of the fence clearly showing it on my property, and even a letter from the county surveyor's office confirming the property line. Our counterclaim accused the HOA and Patricia personally of abuse of process, frivolous litigation, and harassment. We asked for attorney's fees, damages, and sanctions. The discovery phase began in August. Discovery is the period where both sides exchange documents and information relevant to the case. Michael served the HOA with requests for documents, including all communications about the fence, minutes from board meetings where my property was discussed, and any documentation supporting their claim that the fence was HOA property. What we received was laughable. Patricia provided a single email chain where she told the other board members that the fence was obviously HOA property because it bordered the common area. There was no survey, no title documentation, no historical records, nothing. It was literally just Patricia's assertion, which the other board members had apparently accepted without question. We also deposed Patricia in September. A deposition is a formal interview where witnesses answer questions under oath, and it's often where cases are won or lost. Michael had warned me that Patricia would likely be defensive and hostile, but I wasn't prepared for just how bad it would be. The deposition took place in Michael's conference room on a Thursday afternoon. Patricia arrived with her attorney, Gerald Davidson, a heavy-set man in his 60s with a perpetual scowl. Patricia wore a business suit and had clearly prepared herself to be combative. Michael started with basic questions, establishing Patricia's role as HOA president and her length of service. Patricia answered tersely, her arms crossed over her chest. Then Michael asked the key question. "Miss Montrose, what evidence do you have that the fence in question is HOA property?" Patricia's face flushed. "It's been HOA property for the entire time I've been president. We've maintained it, we've replaced boards, we've treated it as our property. But what documentary evidence do you have? A survey? A title document? I don't need documents. I know this community inside and out." Michael slid a copy of my property survey across the table. "Miss Montrose, this is the official county survey for Mr. Reeves' property. It clearly shows the fence is located on his lot, not on HOA common property. Have you seen this document before?" Patricia barely glanced at it. "That survey is wrong." "On what basis do you claim it's wrong?" "Because I know where our property lines are." Michael leaned forward. "Miss Montrose, are you a licensed surveyor?" "No." "Do you have any training in property boundary determination?" "No, but I don't need training to know what the HOA owns." The deposition went on for 3 hours, and it only got worse for Patricia. She contradicted herself multiple times, admitted she had never actually looked at any property records, and eventually became so flustered that Gerald Davidson called for a break. During the break, I stepped out into the hallway with Michael. He was trying not to smile. "That was a disaster for them," he said quietly. "Patricia just admitted under oath that she has no evidence, no expertise, and never bothered to verify her claims before filing a lawsuit. That's textbook frivolous litigation. So what happens now? We file a motion for summary judgment and a motion for sanctions. Summary judgment because there's no genuine dispute of material fact. The survey proves you own the fence. Sanctions because they brought a lawsuit with no reasonable basis. The motions were filed in early October. Michael's briefs were thorough and devastating, laying out how Patricia had ignored evidence, made claims without any factual basis, and wasted everyone's time and money on a personal vendetta. He cited multiple Florida cases where courts had sanctioned plaintiffs for similar conduct. The hearing was scheduled for November 15th at the Pinellas County Courthouse. I took the morning off work and met Michael at the courthouse at 8:30. We went through security and found our courtroom on the 3rd floor. Judge Rebecca Morrison presided over the civil division, and according to Michael, she had a reputation for not tolerating nonsense from attorneys or litigants. She was a stern-looking woman in her late 50s with gray hair pulled back in a bun and reading glasses perched on her nose. Patricia and Gerald Davidson were already seated at the plaintiff's table when we arrived. Patricia looked tense, her jaw set in a hard line. Gerald was shuffling through papers, and I noticed his hand was shaking slightly. The hearing began promptly at 9. Judge Morrison called the case and looked down at the stack of briefs on her bench. "I've reviewed the motions and the responses," she said, her voice crisp and professional. "Mr. Chen, your motion for summary judgment appears to be well supported. Mr. Davidson, what evidence do you have that would create a genuine issue of material fact regarding the property boundary?" Gerald Davidson stood up, clearing his throat. "Your Honor, the HOA has maintained this fence for years. They've treated it as their property, and Mr. Reeves knew or should have known that it was HOA property when he purchased his home." Judge Morrison's eyebrows rose. "Mr. Davidson, I've seen the property survey in the record. It's a certified county survey that clearly places the fence on Mr. Reeves' property. Do you have a competing survey that shows otherwise?" "No, Your Honor, but do you have any title documents, easement agreements, or other recorded instruments that would give the HOA any rights to this fence?" "Your Honor, the HOA's position is that the survey is incorrect." "On what basis?" Gerald Davidson seemed to deflate slightly. "Miss Montrose has been president for 8 years and is familiar with the property." The judge's expression turned icy. "Mr. Davidson, are you seriously telling me that your client's lawsuit is based solely on Miss Montrose's personal opinion, with no documentary support whatsoever?" "We believe that continued possession and maintenance establishes." "Mr. Davidson, this isn't an adverse possession case. This is a case where you sued a homeowner for planning to paint his own fence. A fence that every piece of documentary evidence shows is his property. Did you conduct any due diligence before filing this lawsuit?" The courtroom was silent. Gerald Davidson's face had gone pale. "Your Honor, we relied on our client's representation of the facts." Judge Morrison removed her glasses and set them on the bench. "Mr. Davidson, you've been practicing law for how many years?" 32, Your Honor." "Then you know that you have a duty to investigate the factual basis of any claim before filing a lawsuit. You don't get to blindly accept your client's version of events, especially when it involves easily verifiable facts like property boundaries. This is exactly the kind of frivolous litigation that wastes judicial resources and harms innocent people." She turned to Patricia. "Miss Montrose, please stand." Patricia stood, her face red. "Miss Montrose, you're the president of this HOA, correct?" "Yes, Your Honor." "Did you review any property records before you decided this fence was HOA property?" "I didn't need to, Your Honor. I've lived in this community for 15 years. "That wasn't my question. Did you review any official records, surveys, title documents?" Patricia's jaw clenched. "No." "Did you consult with a surveyor or any other expert?" "No." "Did Mr. Reeves offer to show you his survey when you confronted him?" Patricia hesitated. "Yes." "And you refused to look at it?" "I didn't think it was accurate." Judge Morrison shook her head slowly. "Miss Montrose, you filed a lawsuit seeking $25,000 in damages against a man for planning to paint his own fence. You did this without any evidence, without any legal basis, and without even bothering to look at documentation that would have immediately shown you were wrong. Why? Patricia's composure finally cracked. He was disrespectful to me. He questioned my authority. Someone needed to teach him that he can't just do whatever he wants in this community. The silence that followed was deafening. Even Gerald Davidson looked horrified. Judge Morrison put her glasses back on. Miss Montrose, that is exactly the wrong answer. HOA boards exist to serve the community and enforce legitimate rules. They do not exist to satisfy personal vendettas or to teach lessons to homeowners who dare to assert their legal rights. She turned back to her bench and made several notes. Here's my ruling. Mr. Chen's motion for summary judgment is granted. The fence is Mr. Reeves' property, and he may paint it, replace it, or do anything else he wants with it. The HOA's claims are dismissed with prejudice, meaning they cannot be refiled. Gerald Davidson started to sit down, but Judge Morrison held up a hand. I'm not finished. Mr. Chen has also moved for sanctions under Florida Statute 57.105, which allows sanctions when a party brings an action with no reasonable basis in law or fact. I find that this lawsuit was frivolous from its inception. Miss Montrose filed it knowing she had no evidence, and Mr. Davidson pursued it without conducting adequate due diligence. She looked directly at Patricia. Miss Montrose, you filed this lawsuit in your capacity as HOA president, but you acted outside the scope of your authority. You used HOA funds to pursue a personal grudge, and you wasted this court's time with meritless claims. I am imposing sanctions of $15,000 to be paid personally by you, not by the HOA. Patricia's face went white. Your Honor, I can't. You should have thought of that before you abused your position. Additionally, you and the HOA are jointly and severally liable for Mr. Reeves' attorney's fees and costs. Mr. Chen, please submit a detailed accounting of your fees and expenses within 30 days. Michael stood. Thank you, Your Honor. Judge Morrison wasn't done. She turned to Gerald Davidson. Mr. Davidson, I'm not sanctioning you personally today, but I am putting you on notice. You have a duty to investigate your cases before filing them. Consider this a warning. Yes, Your Honor, Gerald Davidson said quietly. The judge banged her gavel. We're adjourned. I sat there for a moment, trying to process what had just happened. I had won. Not just one, but one so decisively that the judge had sanctioned Patricia personally and awarded me attorney's fees. Michael put a hand on my shoulder. That went even better than I expected, he said with a genuine smile. Judge Morrison doesn't often get that angry in court. Patricia really crossed a line. We left the courtroom while Patricia and Gerald Davidson remained at their table, both looking shell-shocked. In the hallway, Michael explained what would happen next. I'll submit my fee statement within 30 days. Based on the hours I've put in, you're looking at somewhere around $18,000 in attorney's fees. Patricia is on the hook for $15,000 in sanctions, and she and the HOA together owe you the $18,000 in fees. You won't have to pay me anything. They'll pay directly. What about Patricia? Can she actually pay $15,000? Michael shrugged. That's her problem now. If she doesn't pay, you can pursue collection. But Brandon, there's something else you should know. Patricia used HOA funds to bring this lawsuit. That might violate her fiduciary duty to the HOA members. The other homeowners could potentially sue her or remove her from the board. I hadn't thought about that angle. Do you think they will? I think they'll be pretty upset when they find out what she did and what it cost them. Michael was right. News of the lawsuit's outcome spread through Sunridge Hills like wildfire. I don't know who leaked it first, but by the following Monday, my neighbor across the street, a retired accountant named Tom, knocked on my door. "Brandon, I just heard about what happened with Patricia and the lawsuit," he said, looking embarrassed. "I wanted to apologize. Most of us had no idea what she was doing. The board meetings have been a joke for years. Patricia basically runs them like her personal fiefdom, and the rest of the board just rubber stamps whatever she wants." I invited Tom inside and told him the full story over coffee. His expression grew darker with each detail. "This is outrageous," he said when I finished. "Patricia spent HOA money, our money, on a personal lawsuit that she knew was bogus. That has to be illegal. My attorney said it might violate her fiduciary duty to the HOA," I told him. Tom nodded slowly. "We need to call an emergency meeting of the homeowners. The CC and Articus allow for a recall election if 20% of homeowners sign a petition. I think we can get that easily." Over the next 2 weeks, Tom organized a petition drive. He went door to door explaining what Patricia had done, showing people copies of Judge Morrison's order. The response was overwhelming. Out of the 215 homes in Sunridge Hills, 147 homeowners signed the petition demanding Patricia's removal and a full audit of HOA finances. The emergency meeting was held on a Tuesday evening in early December at the community clubhouse. I arrived early with Michael, who had agreed to attend as my attorney in case things got contentious. The clubhouse was packed, with homeowners standing along the walls when all the chairs filled up. Patricia arrived exactly at 7, flanked by 2 of the other board members, both of whom looked distinctly uncomfortable. She took her seat at the front table with her usual imperious expression, but I could see the tension in her shoulders. Tom had been elected to chair the meeting. He stood at the podium and called the meeting to order. "We're here tonight to address serious concerns about the conduct of our HOA president, Patricia Montrose," he began. "3 weeks ago, Judge Morrison of the Pinellas County Circuit Court issued an order finding that Miss Montrose filed a frivolous lawsuit against one of our neighbors, Brandon Reeves. The judge sanctioned Miss Montrose personally for $15,000 and ordered her and the HOA to pay Mr. Reeves' attorney's fees of $18,000. A murmur ran through the crowd. Several people turned to look at me. Tom continued. "The lawsuit was over a fence that was clearly Mr. Reeves' property, as confirmed by an official county survey. Miss Montrose filed the suit anyway, apparently because she didn't like that Mr. Reeves questioned her authority. She used HOA funds to pursue this personal vendetta, and now those funds are gone. That's $33,000 in total costs from this lawsuit. That's not fair," Patricia's voice rang out. "Brandon was hostile to me from the beginning. He refused to cooperate with HOA policies." Tom looked at her calmly. "Patricia, there was no HOA policy about the fence. Judge Morrison was very clear about that. You made up a claim, you pursued it despite having no evidence, and you cost this community tens of thousands of dollars. That's not leadership, that's abuse of power." Several homeowners applauded. Patricia's face was bright red. A woman near the front raised her hand. "I want to know how we're paying for this. Where's the $18,000 coming from?" Tom nodded to another board member, Stephen, who stood up nervously. Stephen was a mild-mannered engineer in his 40s who had been treasurer for 3 years. "I've reviewed our finances," Stephen said. "We have about $42,000 in our reserve fund, which is supposed to be for major repairs and emergencies. We'll have to use almost half of it to pay the judgment and attorney's fees. That means we won't have enough money for the roof repairs on the clubhouse that we've been planning, and we'll need to impose a special assessment next year to rebuild the reserves." The murmurs turned into angry voices. A special assessment meant every homeowner would have to pay extra fees, potentially hundreds of dollars each, to cover Patricia's mistake. Another homeowner stood up, an elderly woman named Margaret who lived near me. "I have a question for Patricia. Did you even try to verify your claims before filing this lawsuit? Did you look at Mr. Reeves' property survey?" Patricia stood up, her chair scraping loudly. "I don't need a survey to tell me what I already know. I've been managing this HOA for 8 years and I know every inch of this property. That fence has always been part of the common area landscaping." "But you were wrong," Margaret said firmly. "You were completely wrong, and now we're all paying for your stubbornness." "I was doing my job," Patricia shouted. "I was protecting this community from someone who thinks he can do whatever he wants." Michael stood up. "May I address the meeting?" Tom nodded. "Please." Michael walked to the front of the room. "My name is Michael Chen, and I'm Mr. Reeves' attorney. I want to make sure everyone here understands exactly what happened. Miss Montrose didn't just make a mistake. She was shown definitive proof that she was wrong, a certified property survey, and she refused to even look at it. When Mr. Reeves hired me, I sent her a detailed letter explaining the law and the facts. She ignored it. She filed a lawsuit seeking $25,000 in damages for something Mr. Reeves hadn't even done yet. He was planning to paint his own fence on his own property." He paused, looking around the room. During her deposition, Miss Montrose admitted under oath that she had no evidence for her claims. She admitted she never reviewed any property records. And when Judge Morrison asked her why she filed the lawsuit, she said it was because Mr. Reeves was disrespectful and she wanted to teach him a lesson. Those are her words under oath. The room erupted. People were shouting questions at Patricia, expressing their anger, demanding her resignation. Patricia stood at the front table, her face a mask of fury and humiliation. Tom banged a gavel, calling for order. "We need to vote. I'm calling for a motion to remove Patricia Montrose as president and as a member of the board effective immediately." "So moved," someone called out. "Second," said another voice. The vote was conducted by show of hands. Tom counted carefully. The motion passes, 119 in favor, 8 opposed. "Patricia, you're removed from the board effective immediately. Please turn over all HOA documents, keys, and records to Stephen within 48 hours. Patricia grabbed her purse and stormed toward the door. Before she left, she turned back and pointed at me. "This is all your fault, Brandon. You've turned this community against me." "No, Patricia," I said, standing up. "You did this to yourself. All I wanted to do was paint my fence." She slammed the door behind her. The meeting continued for another hour as the homeowners discussed next steps, including hiring a forensic accountant to review several years of HOA finances. Several people raised concerns about other decisions Patricia had made, other homeowners she had targeted with baseless violations. As the meeting wrapped up, a dozen people came up to shake my hand and apologize for what I had been through. Tom clasped my shoulder. "We're going to make this right," he said. "Patricia won't get away with this." The forensic audit began in January 2025. The accountant, a woman named Rachel who specialized in HOA financial reviews, spent 3 weeks going through every transaction from the past 5 years. What she found was disturbing. Patricia had been using HOA funds for personal expenses. Not a lot at once, but consistently. $100 here for office supplies that turned out to be personal stationery. $200 there for community meeting refreshments on days when no meetings occurred. She had paid herself an unauthorized stipend of $300 a month for administrative duties that wasn't mentioned anywhere in the CC and Articus. Over 5 years, Patricia had embezzled nearly $28,000. Rachel presented her findings at a board meeting in February. I attended as an observer, along with about 30 other concerned homeowners. Rachel's report was detailed and damning, with bank statements, receipts, and a clear pattern of misappropriation. "This is criminal conduct," Rachel concluded. "The board needs to consider involving law enforcement." Stephen, who had become interim president, looked uncomfortable. "Are you sure? I mean, could this just be accounting errors?" Rachel shook her head firmly. "No, these transactions were deliberate and concealed. Miss Montrose falsified records to hide what she was doing. This is embezzlement." Tom stood up. "Then we need to call the police. We have a duty to the other homeowners to pursue this." The vote was unanimous. 2 days later, Stephen filed a police report with the Clearwater Police Department. The detective assigned to the case, a sharp-eyed woman named Detective Sarah Ramirez, reviewed Rachel's report and interviewed several current and former board members. In early March, Patricia was arrested at her home on charges of embezzlement and fraud. The amount involved, over $28,000, made it a third-degree felony under Florida law. I wasn't there for the arrest, but Tom called me afterward to tell me about it. "They took her away in handcuffs," he said, and I could hear the mixture of satisfaction and sadness in his voice. She was crying and saying it was all a misunderstanding, but the detective wasn't having it. "Patricia's looking at serious prison time if she's convicted." The criminal case moved faster than I expected. Patricia's attorney tried to negotiate a plea deal, but the state attorney's office wasn't interested in being lenient. Patricia had abused a position of trust, stolen from her neighbors, and shown no remorse. In June 2025, she went to trial. I was called as a witness, not about the embezzlement, but about the lawsuit. The prosecutor wanted to establish a pattern of Patricia abusing her authority as HOA president. I testified about the fence dispute, the baseless lawsuit, and Patricia's admission in court that she filed it to teach me a lesson. The jury deliberated for less than 4 hours before finding Patricia guilty on all counts. At sentencing in July, Judge Marcus Thompson gave her 4 years in prison, followed by 3 years of probation. He also ordered her to pay full restitution of $28,000 to the HOA. "Miss Montrose, you were given a position of trust and authority in your community," Judge Thompson said at sentencing. "Instead of serving your neighbors, you stole from them. You used your position to bully people and pursue personal vendettas. Your conduct has caused real harm to real people, and you need to be held accountable." Patricia's husband, a quiet man I had only seen a few times, sat in the gallery with tears streaming down his face. I felt a moment of sympathy for him, caught up in his wife's crimes. After the sentencing, I stood outside the courthouse with Michael, watching as Patricia was led away to begin her prison sentence. "It's over," Michael said. "Finally over." "I never wanted any of this," I said quietly. "I just wanted to paint my fence." "I know, but you did the right thing. You stood up to a bully. You fought back when she tried to abuse the legal system, and you helped expose her crimes. A lot of people would have just backed down." We shook hands, and I drove home to Sunridge Hills. The fence, which I had finally painted last November after the judge's order, looked fresh and clean in the afternoon sun. The whole ordeal had taken more than a year of my life, cost me countless hours of stress and anxiety, and exposed depths of corruption I never expected to find in a suburban HOA. But I had won. The legal system had worked the way it was supposed to. Patricia had been sanctioned, then removed from power, and finally held criminally accountable for her actions. The HOA was under new management, with Tom as the new president and a completely reformed board committed to transparency and actually following the rules. Life in Sunridge Hills slowly returned to normal over the following months. The special assessment to rebuild reserves was kept minimal thanks to Patricia's restitution payments, which came from the sale of some of her assets. The new board implemented reforms, including mandatory financial audits, term limits for officers, and open meetings where homeowners could actually participate in decisions. I became friendly with several neighbors who had reached out during the whole mess, including Tom and Margaret. We started having regular barbecues in my backyard, right next to that fence that had started everything. It became something of a running joke among us, how a simple home improvement project had brought down an entire corrupt HOA board. In August, I received a check in the mail for $18,000, covering all of my attorney's fees. Michael had negotiated a payment plan that included interest. I put the money toward a new deck in my backyard, hiring a contractor without having to get HOA approval because it was entirely on my property and didn't require any permissions under the correctly interpreted CC and Articus. One evening in September, as I was grilling burgers for a neighborhood gathering, Margaret asked me if I regretted not just letting Patricia have her way. "It would have been easier to just forget about the fence," she said. "You could have avoided all the legal trouble." I thought about it for a moment, flipping a burger. "No," I said finally. "I don't regret it. If I had backed down, Patricia would have kept abusing her power. She would have kept stealing from the HOA. She would have kept bullying anyone who questioned her. Sometimes you have to stand up and fight, even when it's hard." Tom, who was standing nearby with a beer, raised his bottle. "To standing up to bullies." "To standing up to bullies," we all echoed and clinked our drinks together. The fence still stands in my backyard, freshly painted in that desert sand color I chose more than a year ago. Every time I look at it, I remember what it represents. Not just a property boundary, but a line I refuse to let Patricia Montrose cross. It's a reminder that property rights matter, that HOA boards have limits to their authority, and that when someone abuses the legal system for personal vendettas, the courts can and will hold them accountable. Patricia is serving her sentence at Lowell Correctional Institution, a women's prison about 2 hours north of Clearwater. I've heard through the neighborhood grapevine that her husband divorced her and moved out of state. The house they owned in Sunridge Hills was sold to a nice young couple with 2 kids who have already become active, positive members of the community. The new HOA board under Tom's leadership has been everything Patricia's board wasn't: transparent, responsive, and focused on actually serving the community rather than wielding power over it. They've fixed long-neglected maintenance issues, organized community events that people actually want to attend, and created an appeals process for violation notices so homeowners can't be arbitrarily targeted. For me, life has settled into a comfortable routine. I still work as a software engineer, still maintain my house, and still enjoy my backyard with its controversial fence. I've become more involved in the HOA, attending meetings and serving on the Architectural Review Committee to make sure it operates fairly and reasonably. Last month, a new neighbor moved in across the street. During a casual conversation while he was unpacking, he mentioned he was planning to replace his mailbox and asked if he needed HOA approval. I walked him through the actual rules, showed him where to find the CC and Articus online, and assured him that the current board was reasonable and helpful. "I heard there was some drama with the old HOA president," he said cautiously. "Something about a lawsuit," I smiled. "Yeah, there was some drama. But it all worked out in the end. The important thing is that we have a good board now, people who actually care about the community. As I walked back to my house that evening, I thought about how much had changed since that Saturday morning when Patricia Montrose first threatened me over a fence. I had learned a lot about property law, HOA regulations, and the importance of documenting everything. I had learned that standing up for your rights sometimes means accepting conflict and uncertainty. Most importantly, I had learned that legal systems, for all their flaws and complexities, can deliver justice when someone has the courage to use them properly. My lawyer, Michael Chen, had been instrumental in that justice. His expertise, his careful preparation, and his willingness to pursue sanctions against Patricia had made all the difference. Without him, I might have won the case but lost a fortune in legal fees. Instead, I paid nothing and Patricia paid dearly, both financially and with her freedom. The sanctions Judge Morrison imposed had been the turning point. Once Patricia was personally on the hook for $15,000, her facade of authority crumbled. The other board members, who had been too intimidated or indifferent to question her, suddenly realized they had been rubber stamping the decisions of someone who was either incompetent or malicious, or both. The sanctions opened the door to the deeper investigation that revealed her embezzlement. Sometimes I wonder what would have happened if I had just backed down that first day, if I had listened to Patricia's threats and left the fence alone. It would have been easier in the short term, no doubt. No lawsuit, no stress, no months of legal wrangling. But the fence would have continued to deteriorate. Patricia would have continued to abuse her power. Her embezzlement would have continued unchecked. And the next homeowner who dared to question her would have faced the same bullying and threats. By standing my ground, I had inadvertently started a chain of events that cleaned up an entire community and sent a corrupt official to prison. It wasn't what I had intended or wanted, but it was what needed to happen. The story of my fence dispute has become something of a legend in Clearwater's legal community. Michael told me that other attorneys sometimes reference it when advising clients about frivolous HOA lawsuits. Judge Morrison's order, with its sharp rebuke of Patricia's conduct and its substantial sanctions, has been cited in several subsequent cases as an example of how courts should handle baseless litigation. For homeowners dealing with overreaching HOAs, my case provided a roadmap. Document everything, know your rights, don't be intimidated by legal threats, and if necessary, hire a good lawyer who specializes in HOA disputes. The sanctions provision in Florida law is a powerful tool, but it only works if attorneys are willing to invoke it and judges are willing to enforce it. As I sit on my deck this evening, watching the sun set over my properly maintained and legally painted fence, I feel a sense of peace. The ordeal was stressful and exhausting, but it was worth it. Justice was served. A bully was stopped. A community was reformed. And I learned that sometimes the smallest things a fence that needs painting can become catalysts for significant change. My phone buzzes with a text from Tom. Board meeting tomorrow at 7. We're voting on new landscaping for the common areas. Hope you can make it. I text back. I'll be there. Because that's the other thing I learned from all of this. Community matters. HOA, when run properly, can actually improve neighborhoods and bring people together. They can maintain property values, organize social events, and handle collective responsibilities that individual homeowners can't manage alone. The problem isn't the concept of an HOA. It's when people like Patricia Montrose abuse the power these organizations necessarily have. Under Tom's leadership, Sunridge Hills has become the kind of community I always hoped it would be when I bought my house. Neighbors know each other, help each other, and work together to maintain our shared spaces. The HOA serves its purpose without overstepping its authority. Homeowners can paint their fences, plant their gardens, and live their lives without fear of arbitrary rules or capricious enforcement. And if anyone ever questions whether fighting back against an abusive HOA is worth the effort, I can point to Patricia Montrose's 4-year prison sentence and $15,000 sanction as definitive proof that yes, sometimes it absolutely is. The fence still needs a fresh coat of paint every few years, of course. That's just the reality of owning property in Florida's humid climate. But now when I paint it, I do so without looking over my shoulder, without wondering if some petty tyrant will try to use the legal system as a weapon against me. I paint it in whatever color I choose, on whatever schedule makes sense, secure in the knowledge that it's my fence on my property, and no one can tell me otherwise without evidence and legal standing. And that freedom, that simple ability to maintain my own property without harassment, is worth everything I went through to protect it.